somehow or other is impacting the people's right to vote. And that's just simply not true. Your beef is really with the legislature and the governor. So if you're going to have a beef, that's the place to address the concerns. The elected officials here actually allowed this matter to go to the ballot when there was a serious question as to whether it was even legal to go on the ballot. And they decided that they wanted to let the people speak, and they let it go forward in light of the law that there was questions about. Let me back up a little bit on this law. In 2006, the town of St. Pete Beach, and all of you can find this on something called the legislative staff analysis, which the legislative staff prepares when they're introducing a bill. And that analysis says that in 2006, the voters in St. Pete Beach did something similar to what the voters here just tried to do. And the legislature, ever since then, has been attempting to restrict the right of the people to vote on this type of an issue. So there was a law in 2011 that restricted that right, here in Palm Beach County, Revere Beach, and I was involved and held a lawsuit about that. In 2012, the city of Boca Raton was involved in a lawsuit about that. And in 2012, the legislature amended that law again to tighten it up and further restrict people's right to vote. And in 2012, when that law had been amended, that's when this commission had the courage to say, let the people vote, even though there's a law on the books that really questions the legality of that vote. Boca Raton had a different approach than Lake Worth. That city went to the legislature, along with other folks on the wells, and lobbied the legislature to tighten that law even more. And so they did. In the 2013 version of the law, not only tightened that door and closed that door to this kind of vote completely, but it also made it retroactive. And I think, no, that's unusual. But that's what the legislature did. They're the elected officials for the whole state of Florida. And they said, we don't want, in the state of Florida, people to vote on these kind of laws. And even if somebody did it since June of 2011 forward, it's null and void. Now, there's not much stronger words in the law than null and void. It means it never happened, didn't exist. It's as if, a do-over when you were a kid playing baseball. That's what it is. So that's really the beef. Now, judges understand your concern. And I'll read to you from a case, what's called the 5th District Court of Appeals from 2011, the first version of this law. As I said, this law has gotten stricter and stricter. So the early version of it, and somebody was appealing, and the court said the same thing that everybody here is saying, same thing this commission has said. The right of the people to vote on issues that they are entitled to vote on is of utmost importance in our democratic society. I think we're good on that. But then the court said that there are issues, such as the right of a small landowner to use his property, because back then the law was restricted to certain size properties, should not be determined by popular vote. And this is an appeals court talking about this law. This law protects the right of the landowner from having to submit their development plans to the general public and ensure that those plans will be improved or not improved by the elected officials in this quasi-judicial process. So even back in 2011, courts are saying, we recognize the right to vote, we also recognize the legislation has the right to restrict that right to vote and give your elected officials in the planning and zoning process. You go through the planning and zoning board, you have those charrettes, ultimately the city commission has 2 public hearings, ordinances, people are sworn under oath. That's the process that the legislature wants followed for these type of amendments. And this comprehensive plan amendments. When people say it's a charter amendment, it doesn't affect the comprehensive plan, then why in the world is everybody upset that the comprehensive plan isn't being amended? Because clearly the charter amendment was intended to affect the comprehensive plan. You can't have one without the other.
Yes, you can.
So there'll be inconsistent. There'll be inconsistency.
So,
and the clerk is being thrown under the bus a little bit by folks saying she didn't transmit. The clerk transmitted exactly what she was supposed to transmit. She sent to an organizational immunity code and then to the Secretary of State the law that was passed and then was repealed by the legislature. And if you looked at the charter, it says there's a footnote right there, and in the lawsuit that was filed against the city, the footnote says this law was passed and the legislature made it null and void. So everything has been transmitted that's supposed to be transmitted. Yeah, if somebody overturns that law, if some court says the legislature was wrong, that's a different story. But right now, they all have sworn an oath to uphold the law. And the law in the state of Florida, based on the legislature, is that that election is null and void. I don't know how you can expect them to say, we're going to disregard the law that we're sworn to uphold, even though they respect the right of the people to vote, and they encourage that, and they let that election go forward, even when there was a question it could. So I don't know what else I can tell you other than, right now, what the legislature has passed and the governor has signed is very clear, null and void. So you can't go forward with the comprehensive plan amendment.
We're gonna have further discussions on this, obviously the LDRs are coming up in the next, so we're gonna be discussing this much further on throughout the course of this. So if we can move it on, we can continue the conversation in the LDR section, or did you wanna comment right now?
I would kind of like to comment right now, since we typically allow the commissioners to comment on public comment.
Yeah, I just meant about that issue.
Yeah.
It was after, came in after.
Oh,
In deference to the seniority, I'd say, of the person who made it, would we like to make an exception? I'm not sure, she might not have been, I don't know, I'm not really aware of the procedures. I don't know. I have no problem with adding her comment.
bring it ever.
I mean,
I don't know, whatever you want.
Close public comment.
we close public comment, I know. Is it possible, is it in reference to the same issue? It's not? Okay, I'm sorry, it came in after public, it was closed, I'm sorry. But we'll address it if we can meet after the meeting, or else at any time with you, to meet personally with you. Okay, thank you.
So, back to the charter amendment issue. Obviously, I'm not an attorney, so pardon me if I say foolish things, but I'm trying to do my job here. I'm looking at the text of, I'm sure the same thing you're looking at, 163.3167, section 8, and the three pieces that to my mind look like they speak to the issue at hand are A, an initiative or referendum process in regard to any development order is prohibited. B, an initiative or referendum process in regard to any local comprehensive plan amendment or map amendment is prohibited. And then C kind of reiterates that it is the intent of the legislator that initiative and referendum be prohibited in regard to any development order. My question is, I'm not hearing anything about charter amendments. And it's my understanding that charters is very much a part of the concept of home rule, that citizens of a particular area have quite a bit of latitude in both being able to vote and being able to determine their surroundings. And I guess I would ask you to give me a little clarification on what of those things that I read. Am I missing something that does speak to charter amendments?
You're correct. I mean, the general philosophy is charter amendments are important and significant. But again, back to, that's why I recommend everybody read the staff analysis of the legislature, because they went through that exact analysis. There are two kinds of charter amendments that we're talking about here. In your law, if you have a general charter amendment, as we do, a charter provision that says people can vote on issues, that's kind of a general, you can vote on just about anything. Certain towns, Yankeetown in particular, and you keep noticing there's an exception in this law that is the Yankeetown exception, because Yankeetown had a charter provision would specifically authorize a referendum on a comprehensive plan amendment. Now, our charter doesn't have that specificity. In fact, very few charters in the state do. So, when the legislature and the legislature or the state settled the case with Yankeetown, so the legislature continues to create and carve out a Yankeetown exception. If the town had a charter provision that says you can have a referendum on comprehensive plan amendments, that would have been okay. But there's very few cities that have that. Yankeetown is the only one I know of. And with the staff analysis here, it says very few local governments have a land use referendum type process in place. We don't. We have what 95% of all the towns and cities in Florida have, which is a general provision that says that people can vote in their charter on a wide variety of things, but it doesn't say the specific words comprehensive. And that's where the legislature keeps tightening their grip, and they keep narrowing it down to that point. That's really where, to use a cliche, the rubber hits the road. And that's why in 2012, when you were considering it last time to put it on the ballot, that was a close call back then, because the legislature amended the law once, tightened it up, and in 2013, they did the best they could to slam the door. And that's really where the problem is, with the legislature narrowing it and narrowing it and narrowing it.
Well-
And I think you know me well enough, no, I'm sorry to give this opinion. It's not an opinion I want to be given, but, you know, my role is to tell you what the law is, the best we can figure it out, and it's not just my head. I talked to the other lawyers in our firm, I've talked to the city attorney in West Palm, I've talked to the city attorney in Boca, both of them have height limit issues, and they all read it the same way. And every city attorney that I've spoken with, or anybody that represents governments, you know, they all read this provision the same way, they all, and it's, again, you know, Vice Mayor Maxwell is the president of the Palm Beach County League of Cities, and home rule is so important. And yet the legislature talks home rule, but they keep taking away powers from local government. I don't mean to be criticizing the legislature, but the reality is, they keep pulling powers away from local government and from citizens to vote. It's not this commission that's doing this, it's the legislature and the government. That's why I say, if you have a beef, that's where it is.
Well, I do have a beef, and I think there are a good deal of people in this room who have a beef, and I have no idea how to solve the legal aspects of it. That's not my thing, and I have nothing intelligent to add to that. I hope other folks do. I do want to go clearly on record that I think it's extremely important, and that's one of the reasons why I was willing to run for office and take personal time to represent people. I feel that the democratic process is very important, and I feel that it is our job as commissioners to, and I've said this many times over the past couple of years, it is our job to go out of our way to make sure that when we do things that affect the physical layout of our city, that we go out of our way to figure out what people want. I think that is an extremely important thing. And we did do that in some fashion. I think one might argue it was reluctantly, but we did have an election. And I don't believe we are doing our best to listen to what we were told. That was a democratic process. That was what America is about. And I think it is our job as commissioners, as elected officials who represent people, to find a way, whether it's directly, whether it's indirectly, whether it's by these things, find a way. We've heard a message. You can't get it much clearer than an election. Find a way to make sure that we do our job of making sure the city does pay attention to what we've been asked, what we've been told by our citizens.
Since we're gonna be continuing this discussion, let's move on at this point. Unless you have any further comments, Commissioners? Okay. Approval of the minutes, I'll entertain a motion. Second.